Okay, now we are into module D. We'll go a little fast. We'll go a little fast because I have to take care of your doubts also. And I also have the responsibility of completing the syllabus without hurting the sentiments of people like Mr. Balaji. And it is better always to complete the syllabus. And if there is enough time, we can always come back to doubts, clarification, and revision. Okay,
Sir,
now.
this speed is enough, sir. Don't
Yes,
go fast, sir.
Mr. Imran.
This speed is enough,
Yes,
sir.
sir. Please
Don't
go
go
with
fast.
medium speed, sir. Not
Sir.
Okay,
medium
okay.
speed is fine, sir.
2 days class is fine, sir.
Agree. I am there as long as you are there, and whatever you want, I will do it. But we should also keep in mind that we should do justice to both. Okay. Yes, Indian Contract Act 1872. I was telling you yesterday, I told you about, see, this is how we should remember, especially from the examination point of view. You should always link. There is a book called Remembering Logical Things Illogically. Please read it. If you get time, you should read that book. Remembering Logical Things Illogically. Yesterday, I gave an example. Negotiable Instrument Act 1881. Then when was this Transfer of Property Act came? You may be scratching your head. But you know, it came in 1882. They are like brothers. You are born in 1881. Your brother is born in 1882. You are born in 1881. Your sister is born in next year. So, Negotiable Instrument Act, then Transfer of Property Act. 1881, 1882. And Contract Act is a little before, 1872. He is like your elder brother or elder sister. This is how you have to sequentially remember things. Remembering logical things illogically. Were we not doing it? Were we not doing during our school time? We used to say, like, if you want to remember indemnity, guarantee, agency, bailment, and pledge, you say IGABP. Remember IGABP. IGABP. What is I? Indemnity. G, guarantee. B, bail. A, agency. P, pledge. This is how we used to remember during our school days. Maybe you have to develop such skill and devise such tricks to remember difficult things very easily. Even though I don't say that we need to cram by heart and all that, but please, you should have your own ways. How do you remember your birthday? How do you remember your best friend's birthday? How do you remember something else? We have our own ways of doing it. How do we remember our vehicle numbers? How do we ensure that it ends in 8, 9, 8, something like that? No? We have our own ways of doing it. So please start practicing it. If possible, lay your hands on that book called as How to Remember Logical Things Illogically. Very interesting book, very small booklet. You can use it for your pastime reading. Okay, Indian Contract Act 1872. There are general principles and various types of contracts. We deal only in contracts. Contract is an arrangement. Between two people. When you think of contract, think that no minor can enter into a contract. No mentally unsound person can enter into a contract. Okay, no insolvent can enter into a contract. So contracts, when you are entering into a contract, you should be a major. But in case of minors, minors can become parties to a contract only to get benefit, not responsibility, not liability. Okay, your partnership can have a minor partner, but he will not be liable and responsible for all your acts and losses. But if there is a profit, he will take it. So please be careful. Don't entertain any minor in any contract. To get into a contract, he should be a major. He should be mentally sound. He should not be insolvent. Okay. Indemnity is to protect against losses. Contract of indemnity, I can give the best example of life insurance policy. LIC policy, na? You all would have taken up to 1 or 2 policies to take care of your savings, to take care of your tax, and also to take care of your health, to take care of your future. LIC policy, insurance policy, is a contract of indemnity because LIC is going to protect you against any losses. If your vehicle also, you will have a insurance policy. If it meets with an accident or if something happens, some accident, you will get the amounts as per that policy. That is why. Otherwise, you don't get anything. Like a safe deposit locker. You pay rent to keep the articles. You don't get anything, na? You don't get any benefit. You don't get interest when you pay the rent for a locker. Like that, In indemnity policy, you only get benefit on the happening of an event. In the event of a contingency, something may happen or may not happen. Like you take insurance for your vehicle, for 1 year, nothing happens, you don't get any money, you don't make a claim. But if you don't take a vehicle insurance, and if something happens, you suffer. So they are not for profit, they are only to protect you in case of need. Especially Corona season, lot of people had to get hospitalized. Nobody knew, nobody was aware of the situation. If they had health insurance, they would have been taken care of. All their expenses would have been met. So insurance policy is the best example for indemnity. Indemnity means to protect. Guarantee means guaranteeing, fulfilling of a promise or payment. I guarantee. What do I guarantee? I perform. If in case you don't do it, I will do it. That is the guarantee. If somebody does not perform, I will perform. That is a guarantee. And that's a agreement. That's a contract. Agency means there are two people. Arrangement. Agency is an arrangement between two parties. To perform something or not perform something, that is called as agency. Bailment. Bailment means to take care of, to protect, to take care of in your absence. If I take care of either your child or your vehicle or something else, okay, you are going for lunch during 2 and 2:30, you are on lunch, and I take care of your counter in your absence. That is called bailment. Or the best example I can give for bailment is when you park your vehicle in the parking station, you are entering into a contract of bailment. That means you are entrusting the safe custody of your vehicle to that fellow who is in charge of that parking area. He will give you a token, and that is a proof that you have handed over the vehicle to him, and it is his responsibility to take care of it. And once you demand or once you come back to the parking place, he has to redeliver the vehicle against that token. And you pay some fees for it, 10 rupees, 20 rupees, whatever it is. Bailment, best example is parking your vehicle. Pledge, we all know that pledge is gold loan. If you give the possession of the security, that is pledge. If you don't give the possession, that is hypothecation. If it in equitable mortgage, if it's a simple mortgage, you don't give the possession of the property to the lender. But if in case of usufructuary mortgage, you will give the possession. Yesterday I was giving the example of mango garden or a house which is taken on lease. You will have the rights to live in that place. That fellow cannot enter. If you have taken a house on rent, whoever it is, even if he is the owner, he cannot just simply come in. You will say, sir, why are you coming? I am staying here. I am paying the rent. You should take my permission. Then only you can come. That means as long as you are paying the rent or agreeable to the lease terms, owner cannot enter. The possession is with the tenant. Yes. 69 people. I think it's going smooth. Going smooth. Contract is an agreement enforceable by law. See, contract has to be enforceable by law. Otherwise, it will not become a contract. Any contract should become enforceable. It should have the support of the law of the land, agreement and enforceable by law. See, now he is giving out another sentence. All contracts are agreements, but all agreements are not contracts. Very, very ticklish. Tomorrow, I promise that I will pick you and take you on my car to the office. This is an agreement or this is an arrangement. I say that, okay, tomorrow I will take you on my car. I will give you a drop. You need not bring your vehicle. Let us save on fuel. This is an agreement between you and me. Or when I take you on my vehicle, you should take care of my breakfast. Something for something. Or when we were children, when we used to go to movies, two friends, what we used to do? Okay, I'll buy you a ticket, but you get me snacks in the interval. Isn't it? So I will buy the ticket for him, but he should take care of me during intermission. Agreement, arrangement. It may not be enforceable as per law. It's only a agreement out of love and affection. This is not enforceable. But contract means it is enforceable. See, earlier days, marriage was an agreement. It was an arrangement. But when you get it registered, it becomes a contract. When somebody does some favor to me, it is an agreement. Baba, please come and do this for me. Yes, sir, I will do it. But when I enter into a contract and I say that you get so much salary, you should get so much leave, you should perform all these tasks, it becomes a contract. So contract is more defined. Agreement is a little vague. It is in general terms. It need not be reduced to writing also. But contract can be reduced to writing and it can be produced as a proof in the court of law and it is enforceable. Tomorrow, I am into a contract to do some work for you. I am a contractor. Yes, BBMP, Bangalore, Bruhat Bangalore, Metropolitan Palike, Bruhat Bangalore, Mahapalike, BDA, any government agency takes contractors to either build buildings, to lay roads, to do something. There are a lot of tasks which are given on contract. When that contract, either of the party breaches, either he doesn't pay money, or I don't do the work according to his expectation, or has laid out in the contract, I am answerable. This is called as contract is enforceable by law. Law can question me. Why did you not pay him? Why did you do this substandard work? See, these contractors, they take money to lay roads, to build buildings, and within a year of building, the building will collapse. Then he is answerable. He is arrested. He is brought to the court of law and he is pulled up and he is made to pay the compensation. See, I think you are getting to know the difference between contract and agreement. Agreement is a promise or set of promises forming consideration for each other. Consideration means हमको क्या मिलता है? What do I get? What is in for me? Like the child asks, na? Child asks the mother or mother asks the child. Mother asks the child, please do this. I think there was a small pause from my side. Whether you noticed it or not, 67 people. Are you
Yes,
with
sir.
me?
Yes, sir.
Thank you. Thank you. There was a small disruption here. I had to mute and also stop the video. Now I'm back. I was giving an example of something for something, like when mother asks the child to do something, to do an errand, hey, go and fetch some milk, go and bring the newspaper. Child will ask, what do I get? Okay, you buy a toffee. Okay, I'm giving you 10 rupees. You have to get me one sachet of milk. Okay, how much is milk? 10 rupees. Okay, I'll give you 2 more rupees. You buy a chocolate. So something for something, even between an agreement between a mother and child also, they have, mother gets the milk, child gets a toffee. This is called as consideration. What is in for me? WIFM. In everything and anything, you ask, suddenly everybody will start thinking, ये काम किया तो मुझे क्या मिलेगा? What do I get when I do this? Then the manager will say in the branch, okay, I'll throw a party. You all work, you bring branch into profit. You earn so much profit. Yeah, everyone get one insurance policy, or everyone get one new account, or everyone get a new housing loan proposal, car loan proposal. Sir, what do we get, sir? Hey, you get an incentive, you get an increment, I'll throw a party to you, you will be recognized. Something either in kind or cash is called consideration. Okay, maybe oral or written. Yes, there can be a oral agreement, but if it is reduced to writing, that is more clear. If the terms of the contract are in writing, there cannot be any deviation. Oral, who knows? We are not living in Ram Raja. Gone are the days when people believed each other and they performed according to oral instructions. But today, world has changed so much. Everything has to be reduced to writing. Your bipartite settlements, your appointment, your pay scales, your increment, everything is in writing. Interview also should get recorded. So that means everything is becoming clear, specific, and all that. But sale, mortgage, and lease are okay. Some examples for mortgage, rent, it's going to be a rent agreement. If it is a mortgage, it has to be a mortgage deed. I told you now yesterday, when it is an equitable mortgage or registered mortgage, a deed will be prepared and registered. All the terms and conditions, even your sanction of a loan, all the terms and conditions are put in the sanction letter. So it's a written agreement. He will also sign. Both manager and the borrower will sign at the end. We agree with each other. That is called as entering into a contract. Any questions so far? 66 people. Thank you. Okay. A promise is an accepted proposal. In a in a proposal, there is a proposal offer and acceptance. We should know these two words, offer and acceptance, and it should be legal. Any contract which is illegal is not enforceable. Tomorrow I enter into an agreement with another person to finish off somebody or to prevent somebody from doing something dangerous ना, वो क्या बोलते हैं उसको, क्या बोलेंगे, हफ्ता, सुपारी, सुपारी. People give supari to eliminate people. This is becoming very prevalent these days. Rowdies, all rowdies take supari to finish off the opponents. But this is illegal. Even though it is a contract, this is not enforceable. Contracts can be enforced only when it is lawful. Lawful. Okay. Now about the words offer and acceptance. In any contract, there is an offer and there is an acceptance. Offer means, okay, like bargaining. When you go to a vegetable shop, he will offer the vegetables at a particular price. Okay, how much is this kilo? Sir, he will say 20 rupees. Then you will say, okay, get me 500, half kilo, 500 grams. That means you are accepting. It means you are supposed to pay 10 rupees for accepting at the rate of 20 rupees. He says 1 kilo is 20 rupees, that is his offer. Maybe you will say, no, 20 is too much. You may bargain and bring it down to 15, 16. So there may be a offer ke liye counter offer. There may be a counter offer, there may be negotiation. But once offer is accepted, that results into a contract. Offer, acceptance. Okay, even in case of offer, and the best example I can give is a boy offers his hand to a girl. A boy offers his hand to a girl. And if girl accepts it, that's going to result in a marriage, which is a contract. If girl says no, or girl extends her hand and boy says no, offer is rejected. Or if I say, I will offer you 10 rupees to do this job, you will say, why 10 rupees? I want 15 rupees. So 10 and 15, counter offer. Offer ke liye counter offer. But when it is accepted, it has to be performed or executed. Minimum two parties. Yes, Contract Act 1872. For any contract, there should be minimum two parties. Minimum. Like in a partnership, there should be at least minimum two partners. Maximum can be 20 or can be unlimited in case of a limited liability partnership. But at least there should be two people. If there are three people, it's a tripartite agreement. I think you are tripartite. There are three people. If there are two people, it's a bipartite. Bipartite settlement. I think you are familiar with these words. Now, bipartite settlement. Your wage negotiations is a bipartite settlement between IBA and the respective unions. If it's a tripartite agreement, seller, buyer, somebody else. In a SHG, self-help group, there will be 20 people on the one side and one bank on the other side. Marketing, selling, buying. Tripartite. So there can be various types of contracts, valid, definite, and certain offer with intention to create obligation, absolute and unconditional. It is no subject to. Once an offer is made, it is absolute. Okay, when somebody says, I am going to sell 1 kilo of brinjals at 20 rupees, it is absolute. Just because he gets a news that brinjals that they are in great demand, he cannot suddenly hike it to 22 rupees. Maybe for the next fellow, he can sell it at 20 rupees. But for this fellow, he has to sell at 20 only, absolute and unconditional acceptance. Once I accept, I also should say, yes, I'll pay 10 rupees. I will not say 10 rupees if they are good. Only when I go home, I cut the vegetables, then see if everything is okay, then only I will pay 10 rupees. No. Ek baar ho gaya, ho gaya. Now you know the difference between being absolute and unconditional. Conditions can be added to a proposal, but acceptance should be unconditional. Intention to create legal obligation. See, contracts must be legal. Yes, there can be a commercial contract, there can be some domestic contract which are not into writing, maybe oral. So you have a domestic help at your home. You will engage her services after fixing the wages. Okay, I'll pay you 2,000 rupees. Every day you should come and take care of my house. You should sweep, swap, wash the clothes, or wash the utensils, whatever tasks which are assigned to her in the beginning. It is a domestic contract. Maybe you will not enter into a written agreement, But these days, that is also becoming very, very popular. You obtain KYC, you obtain people only through an agency. You don't recruit people directly because you do not know the background, wherewithal, and the antecedents of that person. So all contracts are becoming written contracts and they are enforceable. Tomorrow, if there is any harassment, if there is any breach, tomorrow, if you don't pay her wages, she may go to court. Or if she does not perform something which is listed in your contract agreement, you may go to court. Anything is possible as long as it is legal. Acha, this I have told you. Minors, unsound mind, and insolvents are incompetent to enter into a contract. This is an important section. Section 11 and 12. Please note down. Please remember. Please memorize. Section 11 and 12, competency to become parties to a contract. Who is competent? A minor is not competent. A unsound mind fellow is not competent. A lunatic, mad fellow who has been certified as mad by the doctors. He's mad, mentally unsound. Or people under the influence of liquor, alcoholism. Liquor, when somebody is in the influence of liquor, after having consumed liquor, he cannot enter into a contract because he's of unsound mind. You do not know what he's talking. He does not know what he's talking. He's simply blabbering. So we should be very careful about minors up to age of 21. Unsound mind, you know the examples. Disqualified, incompetent as per law. Insolvency, if somebody is declared an insolvent or a person worth पर no पैसा, insolvency बोलते हैं ना, IBC proceedings आ रहा है, companies are being declared insolvent, they are becoming pauper chiti बोलता था long ago, people were being called as pauper chiti, that means become pauper. His liability is more than his assets. He does not have any asset, but lot of money he owes to so many people. Then what we were calling, he's a useless fellow, he's an insolvent. He has become pauper. He has lost everything in the business, or maybe he has splurged it, wasted the money, and today he is not in a position to repay his debts. So what do you do with such people? Will you give any loan to him again? No, they are insolvents. So these three people, section 11, 12, very important. Okay. Section 30, genuine consent. Parties must understand and agree to the subject matter in the same sense, and there should not be mutual or common mistakes. Same sense. What you say, that I should say. I should not interpret. I should not interpret. Same sense. Whatever you mean, I should also mean same thing. There cannot be any difference. Okay, you ask your housemaid, don't come on next Sunday because we are going out of station. Don't come on next Sunday. She should not think that every Sunday is a holiday. Next Sunday also she will not come. You will ask, why you did not come this Sunday? No, madam, you told on that day, no, don't come on Sunday. Are Baba, I told you not to come on that particular Sunday, not Sunday in general. This is how we have to mean. Whatever is said, we should adhere to it. So no common mistakes. Consideration. See, as regards consideration, in Contract Act, there is no mention of consideration. But as per practice, consideration is important. There can be a contract without consideration also. There can be a contract out of natural love. Like yesterday I was telling you, if you are made as an executor or administrator in the will, you are going to perform that without expecting any fees. Especially executor, he is going to execute the task out of natural love. There is no money there. Okay, I ask you, Baba, please do it for me. Tomorrow when you are going there, you please pay this electricity bill also for me. I cannot come there. Anyway, you are going to pay the electricity bill or to pay the land tax or house property tax. You are going there. Please pay my tax also. You are doing it. You are agreeing to it. It's an agreement. It may be out of mutual love. There is no fee there. So there are also instances where there need not be any consideration, but consideration is out of practice. As per, okay, today, well, nothing comes free. Nothing comes free in this world. Everybody expects something. Father, mother, children, everybody has an expectation. Expectation may be monetary or non-monetary. That's why consideration is a very important element of contract. Okay, nothing more in this slide. An agreement made out of natural love and affection between parties standing in near relation to each other and registered. See, it's an exception. Fulfillment of voluntary promise are under legal obligations and time-bound debts. Paying a time-bound debt is a contract, is an agreement. Okay, document time bar ho gaya hai. There is no revival letter. Documents have become expired. फिर भी he undertakes to pay his money. This is a contract without any consideration. Yes. Shall we go ahead? 64 people. But I was very happy on the first day. There were almost we had touched a century. But why is this dwindling today? There are only 66 people. Is it because of weekend? Anyway, you have the whole of tomorrow for yourselves. No? There are no classes tomorrow. And the whole of tomorrow is for you to spend it diligently, wisely. Just don't waste your time tomorrow. Mr. Mohanan every day reminds you that there are only 20 days, 19 days, 18 days. Time is ticking. So next Sundays and all other days, you should work hard. But some discouraging news is that the numbers are coming down. Okay. Lawful object in consideration. Yes, the purpose of a contract should be legal. It cannot be a supari. It is not for doing something antisocial, doing anti-law, against law, taking the law into your own hands. Such contracts are not enforceable. I cannot enter into a contract to do something illegal, to do something antisocial, to do something anti-national. Lawful object and consideration. Object and consideration should not be unlawful, illegal, immoral, or opposite to public policy. Very clear, no doubt about it. I cannot enter into a contract to do something illegal, sale of drugs, illegal. Can I enter into a contract? Can I employ so many people on payment of wages to sell drugs? No. I cannot do something immoral, which is not moral as per the standards of the society. Getting married to a minor is immoral. It is against law. Doing child labor, employing children below the age of 18 for some gainful employment. It is immoral. Harassment. Working hours 8 hours. I make you people work for 10 hours, 12 hours. No rest, no holiday. Immoral. Are opposed to public policy. Yes, it is also policy that minimum wages, maximum number of hours of work, break in between, holiday once in 6 days. These are all as per public policy. I cannot enter into a contract against this. Certainty, agreement must be certain and not vague. See, these are all the characteristics of a contract. It should be certain. I should be asked to do something which can be measured, specific, measurable, action-oriented, realistic, and timely. My contract should be SMART. S-M-A-R-T. What is SMART? S stands for specific, M stands for measurable, A stands for action-oriented, T stands for time-bound. I cannot enter into a contract which will last for innumerable years. I will build this building, sir. How many years? Sir, it may take, let me see, sir. Okay, I will do it. I do not know when it will be over. It is not a contract. If it's a contract, you should know that either 2 years, 3 years, realistic time period should be given. It has to be certain. Building for me. How much building? 2 BHK, 3 BHK, or one bungalow, or one flat, one apartment. You cannot say simply build something. It cannot be vague. It has to be specific, measurable, and realistic. Okay, possibility of performance. Yes, you cannot ask somebody to enter into a contract to destroy Himalayas or clean Western Ghats or divert Kaveri from Bay of Bengal to Arabian Sea, which is an impossible act. No, agreement declared void. You cannot enter into a contract which is against public policy. Agreement in restraint of marriage of any person other than minor. You cannot stop somebody getting married because it is against policy, public policy of the government, as long as he is not a minor. Yes, if you come across a marriage of a minor, you can stop it. Otherwise, Shiv Baba, I think you are getting to know the intricate things about a contract. Agreement restraining a person from profession or trade, restricting practices. Minority Restricting Trade, Monopolies and Restrictive Trade Practices Act. There is a MRTP. You cannot restrict somebody from doing something which is lawful. Agreement in restraint of legal proceedings, something not very much relevant and concerned with our understanding. Uncertain agreements, agreement of gambling. Gambling is illegal. You cannot speculative lottery, buying speculative games. You cannot do all that. So these are all the essential features of a contract. I think you are getting to know just enough. If you know the purposes of contract and essential features of contract, you need not particularly worry about the sections and all these things from the examination point of view. And I am also telling this in good faith and without any risk, without any negligence. If something happens, I only say that you are not lucky. That's all.
If you like our content, do like, share and subscribe.